The next exception is the search incident to lawful arrest. In Riley v. California, the U.S. Supreme Court explained the history of the search incident to lawful arrest exception. The exception was first acknowledged in Weeks v. United States in 1914 when the court acknowledged that the right on the part of the government, always recognized under English and American law, to search the person of the accused when legally arrested, to discover and seize the fruits of evidence of crime. Since that time, it's been well accepted that such a search constitutes an exception to the warrant requirement. Indeed, the label exception is something of a misnomer in this context, as warrantless searches incident to arrest occur with the greater frequency than searches conducted pursuant to a warrant. Although the existence of the exception for such searches has been recognized for a century, its scope has been debated for nearly as long. It has a checkered history. The debate is focused on the extent to which officers may search property found on or near the arrestee. The purposes of the search incident to arrest are first, officer safety, and second, evidence preservation. There are three related precedents setting forth the rules governing such searches. First, Chimmel v. California from 1969 laid the groundwork for most of the existing search incident to arrest doctrine. Police officers in that case arrested Chimmel outside his home and proceeded to search his entire three-bedroom house, including the attic and garage. In particular rooms, they looked through the contents of drawers. The court crafted the following rule for assessing the reasonableness of a search incident to arrest in that case. When an arrest is made, it is reasonable for the arresting officer to search the person arrested in order to remove any weapons that the latter might seek to use in order to resist arrest or effect his escape. Otherwise, the officer's safety might well be endangered and the arrest itself frustrated. In addition, it is entirely reasonable for the arresting officer to search for and seize any evidence on the arrestee's person in order to prevent its concealment or destruction. There's ample justification, therefore, for a search of the arrestee's person in the area within his immediate control, construing that phrase to mean the area from within which he might gain possession of a weapon or destructible evidence. The warrantless search of Chimmel's home did not fit within that exception because it was not necessary to protect officer safety or to preserve evidence. To review, the purpose of the search incident to arrest is officer safety and evidence preservation. The rules relate to those purposes. The arresting officer may search the arrestee's person to remove any weapons the arrestee might seek to use to resist arrest or escape. The arresting officer may also search and seize any evidence on the arrestee's person to prevent its concealment or destruction. And the arresting officer may search areas within the arrestee's immediate control, meaning the area from which the arrestee might gain possession of a weapon or destructible evidence. Turning to vehicle searches incident to arrest. 4 years later, in United States v. Robinson in 1973, the court applied the Chimmel analysis in the context of a search of the arrestee's person. A police officer had arrested Robinson for driving with a revoked license. The officer conducted a pat-down search and felt an object that he could not identify in Robinson's coat pocket. He removed the object, which turned out to be a crumpled cigarette package, and opened it. Inside were 14 heroin capsules. The court concluded that the search of Robinson was reasonable, even though there was no concern about the loss of evidence, and the arresting officer had no specific concern that Robinson might be armed. The court did not draw a line between a search of Robinson's person and a further examination of the cigarette pack found during that search. Having, in the course of a lawful search, come upon the crumpled package of cigarettes, the officer was entitled to inspect it. A few years later, in United States v. Chadwick, the court clarified that this exception was limited to personal property immediately associated with the person of the arrestee. So, for example, a 200-pound locked footlocker could not be searched incident to arrest. The search incident to arrest trilogy concludes with Gantt, which analyzed searches of an arrestee's vehicle. Gantt, like Robinson, recognized the Chimmel concern for officer safety and evidence preservation underlie the search incident to arrest exception. As a result, the court concluded that Chimmel could authorize police to search a vehicle only when the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search. Gantt added, however, an independent exception for a warrantless search of a vehicle's passenger compartment when it is reasonable to believe evidence relevant to the crime of arrest might be found in the vehicle. The exception stems not from Chimmel, but from circumstances unique to the vehicle context. So Rule 1 is search of a vehicle is permissible incident to lawful arrest when it is reasonable to believe evidence relevant to the crime of arrest might be found in the vehicle. Rule 2 is that search of a vehicle is also permissible incident to lawful arrest when the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search. The second rule is less likely to apply than the first rule, given the likelihood that the arrestee will be secured upon arrest, i.e. handcuffed or placed in a patrol vehicle. For your purposes, the key thing to keep in mind is that search of a vehicle is permissible incident to arrest when it is reasonable to believe evidence relevant to the crime of arrest might be found in the vehicle. What is the crime of arrest, and is it reasonable to believe that evidence relevant to that crime may be found in the vehicle? The U.S. Supreme Court has addressed both breath tests and blood tests incident to arrest for drunk driving. For breath tests, because breath tests are significantly less intrusive than blood tests, and in most cases amply serve law enforcement interests, a breath test but not a blood test may be administered as a search incident to a lawful arrest for drunk driving. But for blood tests, a blood test may not be administered as a search incident to a lawful arrest for drunk driving. This next slide has an example regarding the search incident to arrest. Gant was arrested for driving with a suspended license, handcuffed, and locked in the back of a patrol car. Police officers searched his car and discovered cocaine in the pocket of a jacket on the back seat. Was this a valid search incident to arrest? The answer is no. The 5 police officers in that case outnumbered the 3 arrestees, all of whom had been handcuffed and secured in separate patrol cars before the officers searched Gant's car. Under those circumstances, Gant clearly was not within reaching distance of his car at the time of the search. An evidentiary basis for the search was also lacking because Gant was arrested for driving with a suspended license, an offense for which police could not expect to find evidence in the passenger compartment of Gant's car. Because police could not reasonably have believed either that Gant could have accessed his car at the time of the search or that evidence of the offense for which he was arrested might have been found therein, the search was unreasonable. In another case, 1 police officer stopped a speeding car. Belton, the driver, and 4 passengers were inside. While asking for the driver's license and registration, the officer smelled burnt marijuana and observed an envelope on the floor marked Super Gold, a name that he associated with marijuana. Having probable cause to believe that the occupants had committed a drug offense, the officer ordered them out of the vehicle, placed them under arrest, and patted them down. Without handcuffing the arrestees, the officer split them up into 4 areas so they would not be physically touching each other, and searched the vehicle, including the pocket of a jacket on the back seat, in which he found cocaine. Was the search of the vehicle constitutional? In that case, yes. There was a single arresting officer confronted with 4 unsecured arrestees, and Belton and the passengers were arrested for a drug offense, so the police officer could reasonably believe that evidence of the offense for which they were arrested might have been found in the vehicle. In Wyoming, there is an added requirement for searching incident to lawful arrest. The search must also be reasonable under all the circumstances. In Pierce v. State, a Wyoming case out of 2007, the Wyoming Supreme Court explained that non-consensual vehicle searches conducted incident to an arrest must also be reasonable under all of the circumstances. There are a couple of rules about protective sweeps that are linked to search incident to arrest. Incident to arrest, an officer can, as a precautionary matter and without probable cause or reasonable suspicion, look in closets and other spaces immediately adjoining the place of arrest from which an attack could be immediately launched. Beyond that area, however, there must be articulable facts which, taken together with the rational inferences from those facts, would warrant a reasonably prudent officer in believing that the area to be swept harbors an individual posing a danger to those on the arrest scene. Protective sweeps are aimed at protecting the arresting officers. The search must be justified by the circumstances. In Maryland v. Bowie, following a Maryland armed robbery by 2 men, one of whom was wearing a red running suit, police obtained arrest warrants for the defendant and his suspected accomplice and executed the warrant for him at his house. After the defendant was arrested upon emerging from his basement, one of the officers entered the basement in case there was something else there and seized a red running suit laying in plain view. The court held that until the defendant's arrest, the police had the right, based on the authority of the arrest warrant, to search anywhere in the house that the defendant might have been found, including the basement. Entry into the basement was lawful. Seizure of the red running suit, which was in plain view and which the officer had probable cause to believe was evidence of a crime, was also lawful under the Fourth Amendment. To review, protective sweeps are aimed at protecting the arresting officer. You can look in closets and other spaces immediately adjoining the place of arrest from which an attack could be immediately launched. But you cannot sweep beyond that immediate area unless that sweep is justified by the circumstances. You need to have articulable facts that make it reasonable to believe the area swept harbors an individual posing a danger to those on scene.